Okay. A very warm afternoon to everybody. Myself, Ritesh from ICSI. This session is going to be on mediation, and the moderator for the session is our senior council member, Chennur Dwarkanathji. He's an FCS and he belongs to Bangalore. And the speaker for the session would be Ravi Birbalji. So I'll just hand over uh, the command to Dwarkanathji for moderating this particular session. Sir, for you.
Good afternoon, professional colleagues. Welcome you all to the webinar on practical aspects relating to mediation. Keeping up with the commitment of ICSI to provide continuous in-depth theoretical and practical knowledge to its members, the Institute has taken initiatives in the niche area of ADR through webinar series on mediation. This webinar series will help the company secretaries prospecting towards relating fields to become multidisciplinary professionals with inclusion of the new role as mediation professionals. To address us on this particular topic of practical aspects relating to mediation, we have with us Ms. Ravi Birbal, Advocate, Supreme Court and Delhi High Court. Before I formally introduce the speaker, I wish to apprise the participants about the mediation in a brief way. Mediation may be understood as a non-adjudicatory and a relatively informal process wherein the parties participate to mutually negotiate and reach solutions to resolve their disputes. It is a flexible process with numerous variations, but the common underlying factor in all forms of mediation are self-determination and party participating and autonomy, which in fact forms the key principles of mediation. As far as legal legislative framework in India and the introduction of Mediation Act 2003 is concerned, I wish to share that despite the evolving use of mediation as a tool for the disputes redressal across the globe, private mediation in India for a long time has been bereft of proper structure and legal recognition, thus discouraging participation by the parties and consequently increasing judicial workload. Unlike arbitration and conciliation, there was no overreaching law in India that governed mediation specifically. In order to address this issue, the Mediation Act 2023 was introduced to enhance the effectiveness of mediation in India, thereby rendering a comprehensive and elaborative legislative framework for the efficient implementation of mediation. The Mediation Act has been introduced with the objective to promote and facilitate mediation, especially institutional mediation for the resolution of disputes, commercial or otherwise, enforce mediated settlement agreements, provide for a body for registration of mediators, to encourage community mediation, and to make online mediation as acceptable and cost-effective process, and for matters connected therewith or incidental thereto. Now, with the advent of the recent Mediation Act 2023, the existing landscape in the mediation as a method of resolving myriad disputes in the country would be ever evolving. Additionally, while the Mediation Act explores the adaptability of mediation in this new age, digital era, where online mediation platforms and technology-assisted processes are reshaping in the ADR landscape. The question of implementation, however, remains to be enhanced with the passage of time. Now, this is the time for me to introduce the speaker for this particular topic, Ms. Ravi Birbal, Advocate, Supreme Court and Delhi High Court. I welcome you for this particular topic to be addressed to the members. Briefly about the speaker, Ms. Ravi is a practicing advocate since 2003. Was nominated as Ombudsman with the Delhi Legal Service Authority on April April 2022 for service matters for 6 months. In February 2021, taken on board in the process of framing rules of new labor codes 2020 for the state of Haryana, appointed as amicus curiae on several occasions by the Delhi High Court and also as arbitrator by Delhi High Court in some cases. She was also appointed as co-chairperson by Delhi High Court for observing amalgamation of two corporates on one occasion. She represents in various courts and advises corporates, public sector undertakings like Hindustan Petroleum Corporation Limited, Bharat Petroleum Corporation Limited, Bennett and Coleman Limited, Modern School, Delhi Gymkhana Club, etc. She is an honorary legal advisor to Ambassador of Romania. She has been speaker on the prestigious platforms like Delhi Judicial Academy, Delhi Legal Service Authority, the Institute of Company Secretaries of India, PhD Chamber of Commerce, National Commission for Women, National Academy of Agriculture, Research Management, Institute of Chartered Accountants India, International Bar Association, New York State Bar Association in Delhi, National HRD, CAPC, Delhi University, and various colleges on several occasions. She has been monthly columnist with the New India Express from 2012 to 2017. Currently, she is a weekly columnist with the Millennium Post. She has also associated with the Outlook, Money Control, Femina, Business Standard, Navbharat, Amar Ujjwal, Delhi Law Times, etc. She has been previously a part of the ethics committee of Sharaf Eye Hospital, of course, with reference to clinical studies. I once again welcome Ms. Ravi Birbal for this particular webinar, and over to the speaker, please.
Thank you so much for such a generous introduction. And I also look forward to addressing the esteemed audience today. So we are talking about mediation. As we know that life is all about time. A minute gone does not come back. So a time saved is basically life saved. And I don't think it's very fruitful to spend time and actually waste time in litigation. So whatever we can resolve mutually by virtue of mediation is not just money saved, but it is time saved, it is life well spent. And understanding this fact, the legislature has also promulgated the Mediation Act 2023, which we will be discussing today. The act is a long one, but we will be discussing the practical aspects of the act. I'll just share the PPT that I have prepared on this. I hope it is visible. I hope the PPT is visible. Okay, great. So see, mediation started in India right from the panchayat system. It is not a new concept. It's been there ever since ages, since years. And various kind of legal provisions, laws, statutory provisions adopt mediation. For instance, in labor laws, generally, you know, the proceeding starts from conciliation offices before the matter goes to labor court or industrial tribunal. The parties, as per the Industrial Disputes Act, are mandated to try and settle their disputes first. And if the settlement does not happen, then the matter goes to court. So it is a mandatory provision under the Industrial Disputes Act for workmen and industry kind of nature of disputes. Under matrimonial provisions also, under the Family Courts Act, the parties are mandated, the husband and wife are mandated to first try and settle their disputes through mediation talks, settlement, etc. And if it does not happen, then the proceedings go on. In fact, even during proceedings, all of you must be aware of this word mutual consent. Parties are often encouraged to settle their disputes via mutual consent in legal proceedings relating to matrimonial proceedings. Even with respect to disputes regarding child custody, etc., lawyers often encourage the parties to try and settle their disputes rather than fighting out in court. Then with respect to civil matters like property matters, ancestral property, or pursuit for possessions or title or ownership or breach of contract or contract of personal service or recovery matters, matters which are not criminal in nature, right? Matters which are not against the state, where a very grave offense is involved. Except for those matters, generally, even in civil property matters, a mediation is advisable. Matters which cannot really go into mediation would be like where taxes are involved, statutory liabilities are involved, criminal prosecutions are involved, professional misconducts are involved. In fact, even by disciplinary actions are involved. Such matters are legally barred from going into mediation, which also we will discuss today in detail. And but although, like I said, statutory obligations, taxes, etc., cannot go in for mediation, but as you all must be aware, at times government also takes out things like amnesty schemes, where people can actually admit their dues, pay the principal amount or whatever the amnesty scheme says, and then finish off their disputes. That's not really a mediation, but kind of resolving a dispute outside the court, outside the statutory forum. Now, Mediation Act 2023 has been promulgated, and some of the important provisions under the Act would be like this. Section 4. First of all, that if there is an agreement between the parties for going in for mediation, like there's an agreement for arbitration, the mediation clause mandatorily has to be in writing. Only if the parties say that the mediation clause is in writing, the agreement, can both of them force each other to go in for mediation. It can be in the form of a contract, or there can be any separate agreement also for it. The document has to be signed by the parties. It cannot be a document on the plain paper, A telling B that, look, this is the mediation clause, or B telling likewise A that, look, this is the mediation clause. The document has to be signed by both the parties. Only can they tell each other that, look, there is a mediation agreement, so I am asking you to come to mediation cell. You cannot force the other party to come to mediation cell unless he or she has also consented to it in writing. Then not only could this be in the form of a hard copy document, but it can also be in soft copy email, or even, while it doesn't really talk about WhatsApp right now, but I think slowly as the law is going to develop and we will get judgments, etc. But I believe even those kind of pronouncement may come that if parties agree to a mediation by a written mode in WhatsApps, etc., even that would be acceptable. As of now, it says documents which are admissible under the Information Technology Act, like an email, then the mediation would be admissible. Even as per section 4, if supposing in one of the plaints before a legal proceeding, one of the pleadings means a plaint, a document in the court of law, that talks about going in for mediation, and the other party does not deny. For example, one of the plaintiffs, one of the petitioners who has arisen the case says that I want to take you to mediation, and the opposite party does not deny that fact. Even that would be admissible, and the parties will have to go into a mediation talk before the appropriate mediation forum. Then, very importantly, the mediation agreement or the agreement to go in for mediation can be before starting of the case. Supposing the parties do not consent or agree, and the one party says, I am going to fight my dispute, I am not going to go in for mediation. But as and long the case starts, the dispute is taking time, it is getting prolonged, or there are any other change in facts and circumstances, or even if there is no facts and circumstances, both parties get tally with each other and they feel they should both go in for mediation. Even after starting of the case, as per the Act of 2023 and even as per the common law, both parties can go in for mediation. Then there is a concept of international mediation also under the Mediation Act 2023, which is to be governed by the Commercial Courts Act. So whether it is during the proceedings, before the proceedings, even during fag end, I have seen myself in cases, even during fag end of the case, when the case is about to get in, either party or both parties may feel that let's go and have a mediation settlement talk, because that is going to lessen the length of the dispute, and maybe one party who supposes that he or she is going to lose feels that it is better to pragmatic to settle down the case. Then apart from Mediation Act 2023, we also already have concept of mediation, pre-litigation mediation cells in India, and the act also defines about them in section 5. So whether it's a civil dispute, matrimonial dispute, commercial dispute, there's a concept of pre-litigation mediation cell. Before the case has arisen, you can always get a notice issued to the other party and call them to pre-litigation mediation. Under labor law specifically, there is concept of, you can note down, conciliation office. In all other laws, there is concept of mediation, pre-litigation mediation, but only in labor laws under Industrial Disputes Act section 10, there is concept of conciliation cell, conciliation center, where parties go and try to conciliate, mediate their cases. Under other concepts, under other laws like matrimonial laws, civil law, property disputes, you've got concept of pre-litigation cell, where you can sit down, both the parties can sit down, a mediator so appointed by the center or the court is also there, and he tries to help and settle the disputes between the parties, whatever they may be. Now, very importantly, the Mediation Act 2023 clearly lays down cases and events which cannot go in for mediation talks. For instance, prosecution of criminal offenses. So supposing it's a case of murder, rape, assault, or anything, even criminal breach of trust, cheating, or robbery, such cases cannot be settled. That is very clear. Even as of now, by the common law, it is very clear. It's an offense against the state. It's a criminal offense. The offender has to be punished if found guilty, and it cannot be settled. Of course, irregularities, which are of small, meager amounts, that may be settled, and there are evening courts in Delhi and other states for the same. But grave offenses, such kind of offenses where there is prosecution involved, those cannot be settled. Non-compoundable cannot be settled. Then after that, those cases relating to levy, collection, penalty, direct, indirect taxes, those cannot be settled. Supposing you have a Provident Fund liabilities under the Employees Provident Fund Miscellaneous Provisions Act 1952, or you've got a state insurance, ESI liability under the Employee State Insurance 1948 Act, or you've got a liability under the income tax or GST, such kind of cases cannot be settled in mediation forum. You cannot call the statutory authority before you in the mediation forum to settle. That is clearly barred by the Mediation Act. However, like I said earlier, if the government or the concerned department sometimes takes out some amnesty scheme that you pay so and so amount and you finish the disputes, or sometimes like for driving license related disputes or electricity kind of disputes, there are lok adalats which are formulated, there you can go and settle. But otherwise, disputes relating to levy, collection, penalty, taxes, refunds, those cannot be taken to mediation cell. That's a dispute against the statutory department, and that cannot be settled. Now, supposing there is an investigation inquiry going on with respect to an offense committed against a person coming under Scheduled Tribe, Scheduled Caste Act, or Disability Act, or maybe people with unsound mind, or child abuse, those specific kind of litigations, there also you cannot say, okay, I'm sorry, I pay the amount, I settle. No, that has to be only done in the court, and that too if the provisions of the said act allow that you pay and fine them, finish it. That cannot be done in the mediation cell, which is meant only for matrimonial, civil, commercial, labor, or other commercial kind of disputes, not for disputes or offenses or kind of irregularities done with respect to people with disability, unsound mind, deities, etc. Then if there are suits for declaration of title, tomorrow you go and say that I am filing a case, I want possession over Lal Killa or Taj Mahal, you cannot take it to mediation cell and settle. If there's a dispute on an archaeological land, you cannot take it to a mediation cell and settle. So if there is a dispute relating to suits for declaration of title against government, or then that can also not be settled. Similarly, if there's a dispute regarding a professional, like against a lawyer before the Bar Council, or CA before the Chartered Accountants Authority of India, or against a company secretary, or against a doctor, against a professional misconduct, even that kind of a dispute cannot be taken to mediation cell. Only money related disputes, family related disputes, child custody related disputes, labor law related disputes, commercial related disputes, international disputes, which are more of monetary in nature, that kind of disputes can be settled in a mediation cell. Then apart from this, you cannot also have two party go to a mediation cell and settle for a third person who is not present in the mediation cell. That also cannot happen unless it is maybe relating to a child custody in a matrimonial case. That you can, but apart from that, if A and B are going to a mediation cell, they cannot take a dispute which A may have with C, or B may have with C, or A and B together we may have with C, and C is not present in the mediation cell. Even when the agreement is formulated, it is only between the parties which are present in the mediation cell, and not with respect to a party who is not a part of the mediation proceedings. Then apart from that, like we already said, that anything which is beyond the jurisdiction of the act, anything which is like, IB code or anything else which is concerning a specific jurisdiction or statutory authority, those kind of disputes would also not be settled unless the specific act allows them to settle. Then powers of court have also been given in the Mediation Act 2023, that any court can, any point of time, refer the parties to mediation if the court so feels. In fact, today I was appearing in a matter and court said, we feel you should settle this dispute. So the matter was taken to the mediation cell. Honorable courts have also been given full power to send the parties to mediation cell to try and settle the disputes. And in the meantime, courts obviously already have the power to pass any interim directions, like giving a stay, injunction, or any other kind of interim relief during the pendency of the proceedings before the mediation cell. As you all know, often parties take cases to mediation cell to linger on the litigation and even to prolong it. So mediation, as per the act, is also made time bound. But saying that, even for that time-bound procedure, the court has been given the power to protect one of the parties or both the parties by virtue of interim direction like stay, injunction, interim relief, or any other relief that the court feels so appropriate. Another thing, even if the court sends party to the mediation cell to try and settle out the disputes, it is not obligated on either of the parties that they are mandated to settle. They have to try to settle, they have to try their best to settle, but it's not obligated, it's not statutory, it's not mandatory that they must have to settle. They have to try their best to settle. Then Section 8 of the Mediation Act 2023 also refers to the appointment of mediators. So interestingly, while mediator, of course, can be Indian, but he can also be of any other nationality as well. However, when he's of any other nationality, and even when he's Indian, there has to be a certain qualification involved. There has to be preferably some experience involved, and he has to be an accredited mediator. There has to be the minimum qualifications and accreditation involved for the appointment of the mediator. If the parties want, they can also agree, like we have in arbitrations also, they can also agree to the name of a mediator. And like, for example, in construction disputes, it is not necessary that you have only a lawyer or somebody from legal fraternity as a mediator. You can also agree to an engineer, to an architect, or somebody, your common friend, that you feel would be good enough to mediate your disputes. And he can be, or you can also approach the mediation center that will be defined under the Act to appoint a mediator for both the parties. Then as it is next written, that if parties do not agree to one common mediator, they can write to the service provider mediation cell that the mediation cell may appoint a mediator to them. And if they are not happy with the name of the mediator, they can also again ask for the change of a mediator. Then very importantly, not only do parties write to mediation cell to refer a mediator, the mediator also has to give a consent. If the mediator does not agree, he cannot be forced to mediate. He can always say that he does not want to do a particular dispute. So consent of mediator which has been agreed to both the parties, or mediator which the mediation center provides, has to give a consent in writing that he is also agreeable to do the mediation. And then very importantly, when it's the mediation service providing agency providing the mediator, the mediation service providing agency has to see the suitability of the mediator. It has to see that the mediator would be suitable for the particular kind of litigation. It should not be anybody. It should be a person who's suitable. Like, for example, it's a construction dispute, center should see that somebody suitable is appointed. If it's a matrimonial dispute, the center has to see somebody suitable is appointed. It's a labor dispute, employer-employee kind of dispute, a civil dispute, contractual dispute, a suitable person has to be appointed according to the nature of the dispute. Then very, very importantly, Section 10 talks about conflict of interest and disclosure. So the mediator has to very clearly inform if he has got any conflict of interest, if he has appeared as a lawyer for one of the parties, if he knows the parties personally, if he is involved in the subject matter of the dispute, or he is a relative, or any remote kind of conflict of interest, he has to inform in writing to both the parties. If there is no conflict of interest, he has to again give a disclosure that I do not have any kind of conflict of interest. I am disclosing that I am completely impartial, independent. I am not concerned with anybody. And this has to be done first prior to mediation. Supposing the mediator was not aware about this prior to mediation, the mediation proceeding starts, and during the mediation, he comes to know that he was somewhere involved. He remembers it suddenly. Then again, at that time also, he can inform that he may have conflict of interest. He will have to disclose all those reasons to both the parties. That could be a potential circumstance, some personal relationship, professional relationship, even financial. If supposing you're a shareholder of this particular company, you have many shares, then you will have to inform both the parties. After the mediator informs, it is not mandatory that the mediator will be changed. The parties can always say that, okay, fine, we are now aware of this fact, we have faith in the mediator, and we want only this mediator to continue. But if the parties are waiving off this objection and they say we want this particular mediator only, they have to give this waiving of objection in writing. And if they are not happy, they can seek replacement of mediator. Another thing, not just for the reason of conflict of interest, not just for the reason of, having a non-disclosure, even otherwise parties want, they can seek replacement of a mediator. If they feel the mediator is rude, if they feel there is no apparent conflict of interest, but they feel the mediator is bent towards another party, or if they feel the mediator is not competent, they can always write to service provider mediation cell to change the mediator. So these are also the important aspects which have been very clearly defined. It's a very well-defined act framed by the legislature. Then Section 11 says that not just can parties say that we are not happy with the mediator, or the mediator has to refer to conflict of interest, but even if the mediation sentence wants, it can terminate the mandate of the mediator. That is when it receives the application, of course, or if supposing the mediation center, the service providing mediation center, gets some information from somewhere, written or verbal, that the mediator could be involved, could be having some conflict of interest, which has been concealed. Even the mediation center in the middle of arbitration proceedings can cancel the mandate of the mediator, and they will have to appoint a new mediator for the said mediation proceedings. Of course, if the mediator also wants, in the middle of the mediation proceedings, he can always withdraw. Even if there's no reason, he doesn't have time, or he's annoyed by the parties, or feel that he is not willing to do the mediation for any personal reasons or professional reasons, even he can withdraw himself. And once the service provider terminates his mandate, or the mediator withdraws himself, or either of the parties says that, no, we don't want this mediator for any reasons, or there's a conflict of interest, or anything else, or even if there is nothing, but the mediation is not to be done by this mediator, then the mediator goes and a new mediator can be appointed under Section 12 of the Act. Now, very important provision again, that mediation center only of the territorial jurisdiction of where the dispute has arisen, or where the court where the case is taking place is there, only that mediation center can take care of the dispute. Of course, if the parties consent, parties can always say that, okay, fine, we both are in Delhi, we both are rich parties, but we want the mediation to happen somewhere in Goa. We do our vacations also, and we do our mediation also. They can always agree to these kind of mediations also. So that is a luxury which has been given by the Mediation Act, that you are supposed to, of course, have the mediation within the territorial jurisdiction of where the dispute has arisen, or where the court where your case is pending is there. But if you give a consent, then you can always take a dispute to some other location also, or maybe not just for the sake of, maybe one party feels like in a matrimonial dispute, woman is in Lucknow and the male is in Delhi, and they feel that it's better we do where the woman is staying. So even the male can give a consent that we are okay, that maybe marriage is taking place in Delhi, or dispute has arisen in Delhi, or even as per the act, the woman is there, the matrimonial case would also take place there. The dispute can be taken to Lucknow also, and the parties can agree to this kind of a mediation outside territorial jurisdiction. Now, let me tell you, while you have the luxury of taking the dispute to another location under the Mediation Act, but this is not possible under legal proceedings. Two parties, there is a judgment of Honorable Supreme Court of Siemens India, which says that parties cannot decide the place of jurisdiction. It is only as per law. Parties cannot say we will take our dispute to so and so location. It is only under the Mediation Act that you can take the dispute to a jurisdiction where both parties may not be residing, or where the concerned court may not be there. Then, very importantly, Section 15 and 16 clearly lays down that mediator has to be fair and reasonable. He has to be independent, impartial, neutral. If these ingredients are not present, the mandate of the mediator can be terminated by either of the parties, or it can be terminated by the service provider agency also, by the mediation service providing agency also. So mediator has to be absolutely fair, not just fair, he has to be reasonable. He cannot be unreasonable. He cannot tell one party you give 10 crore of rupees while the dispute is only of 1 crore of rupees. So he cannot be unreasonable. He has to be independent, fair, impartial, and absolutely neutral, like we expect from the honorable courts, of course. And very importantly, the Act clearly says that he has to maintain clear and absolute confidentiality of the disputes. He cannot take the name of the parties. He cannot inform about the facts of the cases, the documents that he has gone through outside the mediation cell, either in court or anywhere else. Certain circumstances he can inform, which we will discuss later, but generally he has to maintain absolute confidentiality regarding the name of the case, regarding the parties, or regarding anything with respect to the case. He cannot really divulge out to outsiders, to courts, arbitration proceedings, media, anywhere at all. Then mediator has to meet with both the parties jointly, but if he wants, he can also meet with them separately. However, we generally advise the mediator that if you want to meet one party separately, better not to call them on another day, better to call them on the same day, keep one party outside, meet one, then keep the first party outside and meet the second one. So mediator, as per the Act, has been allowed to, of course, meet them jointly, and he can also meet them separately, though we generally allow to meet separately in the presence of both the parties on the same day, and not to call one of the parties separately. Then the mediator is not bound by civil laws, CPC, Code of Civil Procedure. He is not bound by that. He cannot call for documents, summon witnesses, no. And he is not even bound by that. Neither he has the powers. Powers are very limited, but he's also not bound by that. He's not supposed to summon witnesses, do cross-examination, examination in chief, etc., or frame issues like that. It's casual proceedings trying to just settle out the disputes. Like under Arbitration Act, CPC is applicable to a large extent. In labor disputes also, to some extent, CPC is applicable. Under Mediation Act, it is not applicable at all. Those are totally casual proceedings happening only for the sake of settlement, a general settlement. Then a mediator, as per the Act, has also been given duties that he has to assist the parties, identify what the issues are, what the problem is, clarify their priorities, and try for an expeditious resolution. So that is a giving clarity. The Act also gives clarity to mediator as to what his duties are, that he has to tell the parties that list out your priorities, identify what your issues are. Like in matrimonial cases, you have the issue of alimony, maintenance, child custody, or restitution, or you both want to live separately. What kind of arrangement do you want? So whatever the issues are, whatever their priorities in life are, mediator is supposed to assist the parties achieve that, know that, and then try for an expeditious resolution. Then very importantly, like I said earlier, Section 17 says that mediator cannot represent any of the parties in any court. If today you are a mediator with respect to that subject matter, maybe 5 years later, 10 years later, okay, fine, it's different. But with respect to that subject matter, he cannot be an arbitrator, he cannot be a lawyer or any other capacity. He cannot represent the parties before an arbitral tribunal, before a court, or anywhere. Very importantly, he also cannot be a witness. He cannot go to court tomorrow and say कि हाँ इसने ये ऐसा कहा था, ये बोला था, तो ये तो होना ही चाहिए. No, absolute confidentiality, absolute secrecy. He cannot be connected to parties beyond the mediation cell in court, arbitration forum, as a witness, or anything of that kind. Nor can he divulge any secrets, names, subject matter of dispute, or anything even related to it. Like he cannot, if it's a case of divorce, he cannot enter as a witness in a case of child custody and start deposing about what the conversations and mediations were and who was right and he was wrong. Then apart from this, Mediation Act, see, like I was saying earlier, often parties take cases to mediation cell to linger on, and the legislature understand these kind of situations. So that mediation has been made time bound by the Act, which is 120 days you need to complete the mediation, and you can also extend it up to additional 60 days when both the parties consent to it. So no mediation proceedings beyond 180 days the Act permits. And of course, if you want to still continue with the mediation, you need to go back to court, take permission, and then maybe come back, but not otherwise. Then, of course, like we discussed earlier also, Section 19 says that agreement has to be in writing. Now, this agreement is not about appointment of mediator. This agreement is when the mediation is over, both the parties have come to a consensus. They agree that these are our settlement terms and this is what we agreed to. That agreement is not to be oral. It has to be very clearly in writing, signed by both the parties. If the agreement is not in writing, it is no agreement at all. It has no value. Verbal versions have no value at all. Either it has to be in writing or the matter has to go to court and the court has to pass an order. And if the parties want, they can even have the agreement registered, but that is not mandatory. Then very importantly, the Act gives the prerogative that the mediation agreement which has been entered into between the parties can also cover aspects which are beyond the mediation, right? Which were not subject matter of the dispute. However, that cannot be with respect to a third party who is not a party to the mediation proceedings or the court case which is going on. That also cannot be with respect to any other statutory due because that is barred by the Mediation Act. So any other civil dispute, commercial dispute, or matrimonial dispute or labor dispute between the parties which are beyond the terms of the agreement, which are not barred by the Act, which are not concerning an alien outside third party, that can also be comfortably settled by virtue of this mediation agreement, and the parties would be absolutely bound by it. Agreement can be registered, and when there is no mediation taking place, a no settlement report has to be prepared by the mediator and given to the concerned court or the service provider mediation agency. Then Section 22 very specifically says that mediator, service provider, parties, participants have to keep everything, not just the mediator, as I said earlier, has to keep things secret, but even the service provider cannot reveal, even the staff of the service provider cannot reveal, the parties cannot reveal, or any the participant who is there in the mediation proceeding, who was not a party, like your relative or your cousin or friend or anybody who was coming along with you. They are not barred from coming, but if they come, they cannot reveal the details of mediation outside. Any acknowledgement, opinions, suggestions, promises, proposals, anything, nothing can go outside. Even admissions, even if one party says that, yes, I did do this, yes, I owe money, yes, I have to pay, even such kind of mediation or such kind of admissions cannot go beyond the mediation room. And then any acceptance or willingness proposals made, that can also not be divulged outside. If the mediation fails, it fails. It is accepted, but anything that is said over there cannot be taken outside, because if this starts happening, then people would be scared. They would be reluctant to go to the mediation cell. Any other mediation communication also, even that is not to go outside. In fact, the act very specifically specifies that no audio and video recording. No, there can be online proceedings. There is no bar with that, but no recording, audio, video. And even if somebody has secretly done the recording of an online proceeding, that will have no value. That will have not be taken to be an admission or evidence in any court of law, because the act specifically says that you cannot divulge any secret or confidential information or willingness, proposals, opinions, suggestion, anything with respect to mediation. You cannot go and divulge outside in a court of law or anything at all. Of course, the mediator can use this information as a research paper to enhance knowledge of himself, of people outside, without divulging the name of the parties, without divulging really the exact property, etc. But subject matter he can describe without really giving the details for knowledge, for research papers, for giving lectures. But apart from that, he cannot really share the details, go to court, be a witness, say to somebody outsider or a third person, except for research purposes. He cannot do that. Then section 23 also specifically says no disclosure in court. And of course, section 23 states that if there's a misconduct by the mediator or maybe by one of the parties, that is not to be tolerated. That can, of course, be gone outside and made a complaint against. If supposing the mediator is misbehaving or there's a professional misconduct, the mediator is biased, it is not that that is to be kept confidential. That can be made a complaint against, that can be taken cognizance of, that can be informed to the court or the required agency. He can be changed. So there is no confidentiality with respect to a professional misconduct by anyone, including the mediator. And then if supposing during mediation, the mediator feels that there is threat of committing some very grave offense or even a small offense, or there could be a case of, an act of domestic violence or child abuse or something which could be injurious to public health and safety, that is not to be kept confidential. That the mediator is supposed to inform outsider, the relevant agency or the court or the mediation service provider or whomsoever he feels is relevant. So apart from the name of the parties, subject matter, if there are things like child abuse, domestic violence, misconducts, public health, safety, that can be informed to the outsiders, to the relevant court, not make a public speech about it. Then section 24 talks about the authentication and the signature of agreement, that yes, like I said earlier also, the agreement which has been entered into after completion of mediation proceedings have to be signed, authenticated. It has to be done within the time limit. And supposing in the middle of mediation proceedings, parties feel that there is no point in carrying out the mediation and the mediation should be terminated, or even if the mediator feels that it's a waste of time and money to carry on the mediation proceedings, all parties or the mediator can give a declaration in writing that there is no point continuing the mediation proceedings. Maybe it is just spoiling the dispute further, or maybe it is just wasting time and money as well, and give a declaration that mediation ought not to be continued further, and the mediation in the middle of the proceedings can be stopped there and then. Parties can also opt out. So either of the parties, and it's not mandatory that both the parties opt out. Even if one party feels he does not want to continue with the mediation, he wants to go and fight, it's wasting his time, he can do that. If the mediator feels, he can also do that. So then, okay, now this was about mediation. Now let us understand what the court procedures are. In court, when we go, and why it is important that instead of going in for lengthy court procedures, people should try and settle their disputes. When you go to court, you first file a pleading. Pleading is known as your suit, your plaint, or your claim, or by any other name. Then after that, your opposite side, who is known by the nomenclature of respondent or a defendant, right, he gets to file his reply or written statement or counter, whatever jurisdiction you are in as per that nomenclature. And proceedings happen, as you all know, in civil courts, in matrimonial courts, in writ courts, in labor courts. So according to nomenclature of that court, the first party files his pleading. Thereafter, the other party files his reply. Then once again, the first party files a rejoinder to that reply. And thereafter, if the second party wants, he may file a replication to that rejoinder, or he may even skip that. After the pleadings are complete in civil cases, this aspect is missing in consumer cases and labor cases. There is admission and denial of documents. Both parties have filed their pleadings. They have also filed their documents. The parties go and admit or deny documents of each other. Right? These are very critical procedure, and these are very lengthy procedures. After admission and denial of the documents, then the issues are framed by the court as to what the issues are that are to be adjudicated upon by the court. These are legal terms. Some of you may not be understanding, some of you may be understanding, but I'm just trying to tell you that some of the procedures are actually rocket science. So it makes a lot of sense to go to mediation and settle out the matter. So issues are framed, that what all are the disputes with respect to the case. After the issues are framed, the first party gives his evidence that this is what he has in his favor, and this is the evidence in his favor, along with the documents or some oral evidence or even hearsay. And after that, the second party does cross-examination of the first party. Likewise, second party gets the opportunity to lead evidence, file his evidence by way of affidavit, file the documents, exhibit the documents, and the first party cross-examines the second party on his evidences. After the evidences stage is over, then finally the matter comes to arguments. And in between, from pleading till argument, there are several applications and replies and rejoinders also filed, which takes years together. So even if you have not understood what I'm trying to say, the sum and substance is that court procedures are lengthy, it's very time consuming, and if at all your disputes, getting rid of these court procedures can be settled, provided they come within the ambit of the act. They are not disputes criminal in nature or against statutory bodies or those barred by the act. It makes a lot of sense to your pocket and to your time and for peace of mind to settle it out. Even if you're losing some money, you're gaining time to earn more money out of it. I have personally been part of many mediations. In fact, if you know, there was a big cold drink company years back which was closed, and we settled for about 1,100 workers who came to Delhi all the way from Punjab, and we settled their disputes. And the day in and on, there was a company in Chennai where there was a big time strike, and it was a case regarding general remand. There also we settled the dispute. Then in matrimonial cases between husband, wife, and especially where there's a child involved, nowadays these kind of disputes are so frequent and prevalent. We suggest, rather than going in for such kind of disputes which are emotionally draining for the husband also, for the wife also, time consuming, harsh on the pocket, and worst for the family and for the child, we generally suggest best to settle out the disputes, iron out the differences, and to carry on your life ahead. So whether it's civil dispute or an arbitration matter, even commercial disputes, we suggest, why to waste the money of the company on litigations? Rather, give this money, spend this money on your business, advertisements, to your workers, to your employees, give bonuses, settle out your litigations. So maybe you may be right in what you are saying, but settling out helps you save money, which you can earn from other aspects and other resources. So overall, we suggest that mediation must be promoted, and legislature also understands it. That is why a full-fledged act has been, has been promulgated for the said procedures. So this was about the Mediation Act and the practical aspects of the mediation. Thank you. I think there's a question in the box.
Yeah, I'll come to that. I have one question. What is the difference between arbitration and place of arbitration, Ravi Birbal?
What is the difference between? Sorry, I think I lost your
Hello.
voice. Yes.
Between the seat of arbitration and the place of seat of arbitration
Yes.
and the place of arbitration, please.
Between the seat of okay, the seat of arbitration is mostly in the case of international disputes. Where is the seat of arbitration? And the place of arbitration is normally used for Indian jurisdiction disputes also. That where is the place for arbitration? Is it in Delhi or is it in Bombay or anywhere like that? In international disputes, normally we use the nomenclature seat of arbitration. Am I audible?
Yes, ma'am, you are audible.
Yeah.
Okay, great.
Ma'am, there is a question.
But,
Somebody is
I
asking
think there is
why
some
mediation is required for a company.
Like I said in the last segment when I was talking about that, you may be right, one company may be right, and if it so feels it's right, it should, if it so feels it's right, and it must contest, because the contest is going to create a deterrent, because if it settles the dispute, it is going to further enhance the dispute. It should not settle. But if it is not about creating a deterrent, if it is not about just proving yourself right or wrong, if it is just about controlling the length of litigation, the time span of litigation, cost control, and if it's about a feeling that you may also be wrong, in such cases, there should be settlement. I repeat myself. For example, somebody has done a grave act of non-solicitation, or non-compete, or stealing your confidentiality data, and you feel it should not be settled. Obviously you should not settle, you should contest it out, because contesting and getting a decree in your favor will create a deterrent for the other employees and other people from the similar acts. But if you feel that you have illegally terminated an employee, and somewhere maybe the termination was right, it was a case of non-performance, the employee was not doing a good job, but you feel that you could have somewhere followed principles of natural justice, you could have somewhere done an inquiry, it was better to have followed some procedure, and you could also be wrong on that count. So it is better to settle it out. If it is not creating a deterrent, if it is not rising further disputes, if it is just giving you peace of mind and saving from cost, settle. But if you have to set a precedent principle, don't settle. It depends case to case basis. Even if there's a dispute between two companies, right? One company has solicited your information, taken your confidential information, don't settle, because you want to create. If somebody has taken away your trademark or your copyright, don't settle. But if you want to, if you think that no, it's okay, the other party has given an assurance that they are not going to further use it, and even if they are not paying you damages, but they're giving you such kind of an assurance, you're protecting your trademark, your copyright, and it is not really creating a wrong example for others, you should settle. Why contest? Depends on case to case basis. I think there's a technical glitch somewhere.
Hello.
Yes, I can hear. I can hear.
Yeah. I think I'm not able to see any questions as such here. Are you able to access, madam, any questions?
Some questions came while I was talking, but I can't see. I can see only one question now.
Yeah, Tanvi or somebody can read out the questions. I'm not able to access the questions, please. Rajesh.
There was one question. There was one question with respect to the seat that I was answering, but there was a technical glitch. I think
that question was raised by me.
Yeah,
actually.
that question. Yes. So see that, like I said, it's more prevalent in the Indian and the international disputes, but there's also one key difference to it, that venue is basically just the geographical location of it, but seat determines the legal jurisdiction of it. There's a difference in geographical location and the legal jurisdiction. So that is also the difference between seat and the place. Place is only defining the geographical location of it.
Yeah.
But seat would be the legal jurisdiction of it.
Tanvi, any more questions, please? Hello. Hello, madam, are you able to hear me, please?
I'm able to hear you.
Yeah. Hello. Rajesh, can you read the questions, please?
Was my voice audible when I was just talking about the seat and the venue part of it?
Yeah, it was clear. It was clear. I heard your answer as well.
There's an absolute sea difference between arbitration and mediation also. Arbitration are more in the nature of judicial, quasi-judicial proceedings, but mediation is not judicial at all. Mediation are informal proceedings to settle out disputes. Arbitration is basically adjudication, when both parties agree for adjudication outside the court by an arbitrator, where there is filing of pleading evidence, though some procedures can be waived off as per the act. That is arbitration. But in mediation, there is no concept of pleadings or evidences or cross-examination or issues. It's just an informal way of settling out the dispute.
RK, can you read the questions, if any, please? Hello.
I think there is one question I can now read, which says, if one of the party on mediator discloses confidential information to the third party, is it possible to initiate criminal proceedings against such party? Well, that's a good question, although the Act does not really provide for penalties for doing that as of now. But I believe, yes, it can. However, a lot will depend upon the magnitude of confidential information that has been shared. It depends what kind of information has been leaked out. So it depends. If just some small aspect of it, maybe you can, because that's a criminal breach of trust in a way. You can. But if it is very prevalent, very relevant, then yes, you can. And not just criminal, you can even initiate civil proceedings. And you can also initiate proceedings for professional conduct by the mediator, and not to be appointed as a mediator. More than civil and criminal, I would say more in the nature of professional misconduct by the mediator. Such a proceeding has to be initiated to bar the mediator from further acting as mediator in other proceedings. Okay, somebody has asked a question, a brief difference between arbitration, conciliation, and mediation. Now, see, there's a huge difference between arbitration and mediation. And there's a slight difference between conciliation and mediations. Arbitration, like I just said, those are those judicial, quasi-judicial kind of proceedings where the claims are adjudicated. One party is said to be right, another is said to be wrong. and there's a decision, there's a judgment, there's an award which comes from the arbitrator. In the meantime, the parties can also settle while the arbitration proceedings are going on, or the arbitral award can also be an award of settlement, right? That is, arbitration is basically like a court proceeding where proceedings happen. It may culminate into settlement, it may not culminate into settlement, but it definitely has to result in an arbitrational award, which talks about one party being right, one being wrong, or both being right to some extent, both being wrong to some extent, some relief being granted, some reliefs not being granted. That is arbitration. Mediation is no adjudication. It is something very away from adjudication. It is peace talks, settlement talks. No one's talking who's right, who's wrong. And even if somebody is talking right or wrong, it's in a very informal sense. It's in a very informal sense. It's just about coming to something as a middle part to settle out. The whole intention of mediation is to finish off, iron out the disputes and not to linger it on, right? Conciliation and mediation, there is not much difference. Both means to mediate or settle out the disputes. Just one thing, conciliation is more done in, conciliation word is more used in labor laws, where under Industrial Disputes Act, Section 10 talks about the conciliation machinery. And even in the family court matrimonial, we sometimes talk about conciliation. And conciliation normally is not a word which is very much used in commercial courts act or arbitrations or other civil disputes. It's more used in other kind of disputes. But there is not much difference between conciliation and mediation. Both places require counseling the parties and to settle the disputes. They are just two sides of the same coin, I would say. Arbitration is something absolutely different. That's more of a legal adjudication of the case. Okay, now another one, Mediation Act is effective as on date. Yes, of course. It is absolutely effective. And next is online arbitration mediation in India. In term of it is online arbitration mediation in India in term of Arbitration Act. I mean, I don't know. I understand what it means is online arbitration mediation in term. Yes, of course, yes. Mediation Act also says that one can carry out mediation online, and even arbitrations can be done online. In fact, pandemic we were doing, I was also appointed in many cases. So I was also doing our online arbitrations, and even post-pandemic, it's become a norm. We can do arbitrations physically also, hybrid also, and online also. The regulations allow the same. Even Mediation Act recognizes online. There cannot be a recording. There cannot be a record. Mediation Act bars audio recording or video recording of the proceedings, but it is absolutely allowed to do it through online mode. The Act will apply to breach of personal data. Can you please read the full form of DIDP Act? Can somebody kindly give the full form of DIDP Act?
I will try to.
Definitely a breach of personal data. Definitely a breach of data. Definitely a breach of data. Revealing confidential information is against the provisions of the Mediation Act. It is against the provisions of other provisions also. But if you can give me the full form of DIDP Act, I will inform whether it is a violation of that specific act or not. However, it is definitely a violation of many of the statutory provisions. Confidential information being one of them, criminal breach of trust being another of them, information technology also it could be one of them, cybercrime also it could be attracted, Mediation Act of course is attracted, but I need to know the full form of DIDP Act.
See, DPDP is there. That is Digital Personal Data Protection Act.
Of course, yes, DPDP is there. Yes, of course it is. Of course it is, but it depends if the data is digital. If the data is not digital, it is not. It is digital protection. It is not a violation of the Digital Act. Only if the data is digital is it a violation. If the data is not digital, it is not in soft copy, it is a hard copy document, or it is regarding another personal information, then it does not get covered by this act. It may be a violation of the Mediation Act. It may be a criminal breach of trust. It may be, depending upon what is leaked, it could also be covered under POSH Act. You never know what is leaked. So if it is digital, then yes, of course, of the Digital Protection Act also. And the Information Technology Act also.
Yeah, I think there are no more questions that have been posted.
There is one more question: is online mediation
Yeah,
term of the Arbitration Act? And it says specifically considering the online dispute resolution mechanism of SEBI. Yes, so I've already answered that. Mediation Act can definitely be done online. However, I don't think we should write the name of SEBI over here, because Mediation Act specifically bars mediation proceedings between individual, company, corporate against any statutory body. So against any statutory body where there is taxes or some liabilities involved, then that cannot be taken to mediation. Mediation Act, talking about holding of online procedure, is something which is independent of SEBI or any other act. That is under the Mediation Act. It is not connected to anything else. Even court proceedings happen online. Even arbitrations happen online. Even labor offices sometimes use online procedures. Even family court uses online procedures. So that is independent of all of it. Online procedures can happen. Online proceedings, mediation talks can happen under the Mediation Act. The agreement can be signed and also be shared virtually, and that cannot be revealed to other people.
I think there are no more questions that have been posed. Ms. Ravi Birbal, it's an excellent presentation that you have done, covering various aspects under the Mediation Act 2023. Trying to say the evolvement of the concept of mediation as such. Then under the Mediation Act, various aspects such as the basic requirements under the Mediation Act, like having agreement in writing, then signing and other aspects. Then coming to pre-litigation mediation is the concept which you have covered, dispute not fit for mediation. Then the powers of the court, the appointment of mediators, who can appoint, how their services can be terminated. Then mediation service providing agencies and their role, and conflict of interest by the mediators, and what would be the consequence if they have got the interest, the mediation of a particular subject. Then service providers can also terminate the mandate that has been given to the mediators. That's what you have tried to cover. And territorial jurisdiction, and of course what rights the mediator should have, the role of mediator in the proceedings while conducting the mediation proceedings, and of course the timeline for disposal and additional timeline that can be granted, and maintaining the confidentiality by the mediators, and also covering the aspects relating to virtual proceedings while doing the mediation, and of course court proceedings, and the other matters which you have covered very elaborately. I wish to thank on behalf of the Institute of Company Secretaries of India and the participants who are present in this virtual meeting, please.
Okay,
I once again thank you for your time.
I would want to interrupt you. That DPDP Act that we were talking about,
please.
I just checked that Digital Protection Act that we were talking about. According to what I have checked, that act has been passed by the Houses of Parliament.
Yeah.
It has not been notified as yet. Kindly appreciate whenever there's.
So it is yet to come into force then.
Yes, it has not, like the labor courts. They have been passed by the House of Parliament. They have received the President's assent. But if my information is correct, as per Google, it says it's not brought into force as yet. It's an act of 2023 only, and it's DPDP.
Okay. Thank you very much for the input, please. Instant response from. Thank you
No,
very
I
much.
just checked. I was wondering.
I thank you for your time and and time spent with us by sharing your knowledge on Mediation Act. Thank you very much, please.
Thank you. Pleasure and a
Thank you.
privilege. Thank you so much.